Thanks very much, Roland, for reaching out to me. Happy to speak with you. And I will tell you a little bit about my professional background and my history with bankruptcy cases. So I'm a partner here at the New York office of Catton. And in the New York office, I am part of the aircraft finance practice group. So aircraft finance has been my practice for over 30 years now. And I approach the world of bankruptcy through that lens. So my career has been long enough at this point that I've gone through several rounds of bankruptcies of domestic airlines, let alone non-US airlines, going all the way back to the old original Continental and Pan Am and Eastern, and back to the late 1980s, where we did lots of interesting litigation work in bankruptcy court. For example, I won't get into too much detail, but there's a specific section of the bankruptcy code that deals with bankrupt airlines, Section 1110, and the particular rights that the lenders and lessors to the aircraft aviation community have to exercise remedies notwithstanding the automatic stay. And I actually did, with my colleagues at the time, some groundbreaking litigation on the application of Section 1110. More recently, of course, I've been involved with the latest round of U.S. airline bankruptcies. Now there are a couple. Since the pandemic, the U.S. airlines haven't tumbled into bankruptcies. There are a couple non-U.S. airlines that have taken advantage of the American bankruptcy courts. But I was heavily involved in the last round, which ended, I guess, with American Airlines filing in 2011. That's been 10 years already. The types of transactions that I regularly deal with, leveraged leases, ended up having some particularly interesting issues in the bankruptcy court at the time, which is the subject of a whole separate conversation. But we spent some time doing, again, some fairly groundbreaking and innovative work on tax indemnity agreement claims, which are part of the domestic leverage leases that were done at the time. So I'm an aircraft finance lawyer, and my bankruptcy experience is whenever mostly the domestic airlines tumble into bankruptcy, and then also representing lessors in liquidations, insolvencies, bankruptcy-related matters for airlines outside of the United States. Those tend to be, for the airlines outside the US, much cleaner. It's less of a process than Chapter 11 here in the States, particularly when you're dealing with somewhat smaller airlines. It's mostly a liquidation process. The claims and issues that we deal with for the non-US airlines, interestingly enough, have to do with the aircraft being seized by airport authorities or navigational authorities for non-payment of charges, which the authority can seize the aircraft, and that those charges are a liability not only of the airline but also the aircraft owner. So the lessors have to pay to get their aircraft out of these airports. So that's a big part of what I've done on the non-domestic side recently, because more airlines have been outside the U.S. have been so affected by the pandemic. I think that deals with my professional background. Of course, we have a large and varied bankruptcy practice here at the firm, dealing with all sorts of bankruptcy related matters. I think we have a particular focus in, especially these days, in retail bankruptcies, representing various parties in those. But that's something our bankruptcy, dedicated bankruptcy practitioners deal with more than I do. So let me talk about the article here. The case was of particular interest to me for a couple of reasons. One is, as I said, there has not been a deluge of bankruptcy Chapter 11 filings because, as a result of the pandemic, unlike what we've seen in the prior business cycles. And so any cases that come up in a U.S. bankruptcy court, particularly dealing with my industry, with leasing, with leverage leasing, with equipment leasing, I just find rather interesting and instructive. If issues such as these are only dealt with every 10 to 15 years or so, it is helpful to see how a contemporary bankruptcy court would deal with some of these things. In addition to the fact that this is an aircraft leasing case here, I found the debtor to be rather interesting because the debtor itself is somewhat outside of the profile of a major U.S. airline here. So the debtor happened to be a charter airline, and so a somewhat smaller company and operating in less of kind of a planned Chapter 11 strategy. What we've seen with the airlines in the States over the decades is that before filing, they have they hire their advisors, financial advisors, lawyers, and have a very well thought out restructuring plan for Chapter 11. There's not a lot left to chance. And of course, I've been involved with, on the lessor side, on lease restructurings and amendments, and the efforts of the airlines to right-size their fleets and mark the rent to market and reduce return conditions and avoid obligations. And it's a rather well thought out plan. And as a result, there probably are fewer novel issues that come up and end up being litigated in an adversary proceeding in the Chapter 11. I think because this charter airline is somewhat outside the mold of a major U.S. airline, and the plan, I guess, was a little bit more haphazard, maybe. It allowed for some issues to be considered by the bankruptcy court that might not have arisen in a bankruptcy of a major airline. So and the other thing that interested me is the case, the opinion that came out. It actually dealt with a number of interrelated but separate bankruptcy issues, two others of which were the subject of other aviation advisories that we have put out and that are on our website. The opinion itself is rather lengthy and I thought well reasoned, and I thought that the trustee and the interested parties really litigated the issues very vigorously at this stage, and that produced an opinion that I thought was that had a lot of meat to it and really considered the precedents, considered the issues here. The highlights of this article and this portion of the opinion have to do with preference payments. So within the preference period, 90 days, a shareholder of the airline, on behalf of the airline, made a large payment of several months' rent for these aircraft, or 1 month for 3 aircraft. and well within the preference period at a time when the airline was tumbling into bankruptcy. Usually with the major airlines, what you see is that everything is going just fine, and all the payments are being made on time, and everything is quite normal and quiet, and there's not a lot of dispute or enforcement action. And then the petition is filed, right? And there's sort of a well thought out plan, what happens thereafter. With this debtor, there was a lot of distress related activity that was going on before the petition was filed. And that, I think, is really what gave rise to the opportunity for the preference litigation. And as I went through the facts of the case having to do with this issue, I said to myself, well, there are sort of structuring issues that are going on here that the court is discussing that I deal with all the time when I structure the deals. And the main one, I think, has to do with the very commercial issue of whether a lease is a true lease or operating lease, as opposed to a disguised security agreement. For leases, so first of all, commercially, you can have an operating lease where the lessor has a meaningful residual interest in the aircraft at the end of the lease term. The lessor and the lessee anticipate that at the end of the term, the aircraft will be redelivered by the lessee in a certain redelivery condition to the lessor, having a meaningful value. And there are tax and accounting guidelines that that specify this. But commercially, the aircraft is coming back, and the lessor would intend to either re-lease it or sell it off in whole or in parts at the end of the lease term. Conversely, in a finance lease or disguised security agreement, or full payout lease, it has their various terms of art. The commercial intention of the parties is that the economics are of a loan. The payments under the agreement will be made, and once they are made, the lease will provide that the lessor will convey title to the aircraft to the airline. So that is a loan with payments that are really structured as loan payments, and it's a secured loan because there's an aircraft there, and the lessor will hold the title to the aircraft as security. What made this case interesting, so commercially, this is a disguised security agreement finance lease here. What the parties want to do commercially, that really governs whether the debtor slips into bankruptcy and the preference payments here. What you're dealing with is the parties' commercial expectations, and for the transaction, that really is what has to govern. But there are some things that you can do when you're structuring the deal, which if the airline slips into bankruptcy, we see from this opinion, will have an effect on the ability to collect, preference payments, the exercise of remedies. In a lease that's governed by the law of a state of the United States, you can call the document a lease, but the form will give way to the substance. So under US law, a judge will take a look at your lease and analyze the payments and whether there's a meaningful residual for the lessor at the end of the term, and say, I don't care if the cover of your document says lease. What you have here in substance is a disguised security agreement, and legally it will be treated accordingly. That's the rule under US law.
As a defendant, you want to have a lease, because leases are usually structured so that each month you're prepaying for that particular month, so that there's no antecedent debt. So that's the reason you prefer a lease, correct?
Well, there are countervailing considerations here that have to do with the bankruptcy. So what parties do is the English law, and this was discussed in the case, under the law of England and of countries that derive their law from England and various other jurisdictions, the form of the document controls what it is. And what the parties did here, and this would have been the choice of the lessor and its finance party, what they did was to elect to have English law rather than New York or California law govern this document, because they wanted it to be treated as a lease, notwithstanding that the economics were that of a secured loan, and that under New York law, this would be treated as a secured loan. The reason they wanted that is that they wanted to get the ability at some point in the course of bankruptcy or non-bankruptcy default to repossess the aircraft, and to have the lessor be able to retain the aircraft and hold it and sit on it and sell it off, and not be under a duty to use commercially reasonable efforts to sell it off and account.
So they were not anticipating that they would also get a benefit if they were sued for a preference, and if it was considered a lease, correct?
Right. Now the flip side is that the advantage of getting the lease treatment by merely electing English law is that you can eventually repossess without any duty to account for the excess over the value of the aircraft to the lessee. On the other hand, your deficiency claim against the debtor lessee will be unsecured. You may have a security deposit, but if it's a secured loan, you're entitled to the full security to the value of the aircraft, right? So that is the trade-off here. But it, and I'm sure that the parties, the lender, the lessor, the KVIC here, were not thinking of the preference issue. They were thinking of the repossession, and whether they'd have to, lessor would have to sell off the aircraft. That I think was the consideration, because that's how these financings work when you have what is in reality a disguised security agreement governed by English law. That's why it's structured that way.
So basically they got a bonus by being immune to a preference lawsuit as well.
Right. And then it was actually, and then the other thing, besides having the bonuses, was it actually going to be upheld? Because when you structure a deal like that, and you have English law, and you end up in, if you're what you have to be thinking of, I guess, in the back of your mind is that your debtor, the lessee, is a U.S. based entity, and if it's going to be seeking bankruptcy protection, it's going to be in a U.S. court. Will a U.S. bankruptcy court uphold that choice of law, given that in the states here, we believe in substance over form? So the next issue that was really interesting, which I think is instructive to parties who are putting their deals together is that this bankruptcy judge, in any event, we can't guarantee what other bankruptcy courts will do, but this bankruptcy judge was unmoved by the very real argument that this was a disguised security agreement, and that's what the trustee argued, because that supports the antecedent debt and the preference action. But the judge was unmoved by that. The judge had no trouble for public policy reasons or anything else to uphold the choice of English law. So I think that fact right there, giving people now structuring their deals the expectation that there is this precedent here, recent precedent, that a court will uphold the English choice of law. So I think that is a very important consideration, very important takeaway for people structuring deals going forward. So this earmarking defense, that's something that you probably would not see with a major airline, but for smaller carriers, charter carriers, something that's not publicly held, startups. These are the types of companies where you're going to see a sponsor. You might see a private equity investor. You could see a shareholder, somebody providing credit support. And so this is again, sort of looking prospectively, what's your takeaway here? So for the smaller debtor, the situation here, I think, with the earmarking doctrine, that could have been avoided. Hindsight's 20/20, of course, but in a case where a shareholder, for example, is going to step up and make a payment on behalf of the lessee, it is very important to properly document that, and before the money changes hands, just to, and again, that's sort of a fairly easy fix. Some of these things, well, if commercially I've got a true lease, and that I'm sort of stuck in my commercial framework, but for it would be fairly easy. The judge is giving a roadmap for what to do in order to preserve that earmarking defense. So it would have been possible to keep the money away from the trustee by taking some fairly simple steps and having like a nice roadmap saying this money is earmarked. It's not just being poured into the lessee. It is allocated specifically to these payments under this lease agreement. And then I guess the other takeaway is, again, particularly when you're dealing with a lessee who is sliding toward bankruptcy, perhaps, is to deal with it in a consistent manner. When I'm dealing with a defaulting lessee, I like to advise my clients to send in a default notice promptly. Sometimes people get into trouble where they sort of do nothing, right? I think you have to really address defaults directly. If you're willing to do an accommodation for the counterparty, do a forbearance agreement, do a lease amendment, do something explicit. What you don't want to do, or if there's a default and you're not inclined to do a forbearance, then be consistent in taking enforcement action. Send out a default notice, and do the formal process. Don't just let it kind of slip or just devolve into phone calls or emails or things like that, because it was this inconsistency which ended up being threats, in this case, that led the court to say, well, that payment might have been made in an ordinary course, but you lessor, your erratic action kind of prevented that from happening. So that's kind of a forward-looking takeaway as well.
Right.